Welcome to Mayor Brown's International Arbitration Across the Pond podcast. Each episode is designed to provide insight on legal issues and other matters affecting international arbitration in the UK, US and around the world. The podcast is presented by two of Mayor Brown's international arbitration partners, Kwadwo Sarkodie from the firm's London office and Charles Harris from the firm's Chicago office. You can subscribe to this podcast on all major podcasting platforms, as well as Mayor Brown's YouTube channel. We hope you enjoy the podcast.
So Kwadwo, this is probably the most prepared or unprepared we've been for our podcast, I would say. What do you think?
Indeed, but it's a subject we know well, Chucky. So hopefully
right.
our general thoughts and observations of this should still be of some value.
Right. So our typical protocol for the listeners is to do a pretty detailed outline about who's going to talk when and that type of thing, even though it is a lot of it is ad hoc and on the fly. But today we didn't even discuss who would be opening up the topic. So why don't we discuss that now? Do you want it to be me or do you want it to be you?
I'd love the chance to open up. If that's okay with
Go
you.
ahead. Yeah. You're probably better at it.
So thanks very much, and welcome again to all of our listeners. And hi there, Chucky. Good to see you doing well.
Good to see you too.
So we're well into the COVID period now. Parties, practitioners have begun to learn to adjust, and we just thought this was a good chance to take stock, looking at remote and virtual hearings, how those interact and can be used to support arbitration. But also, as time has gone by, we've now seen a few examples of where the courts have actually considered virtual hearings, both in relation to court hearings, but also, more interestingly, for the purpose of this podcast, in relation to international arbitration specifically. And there have been a few challenges which have been decided, which we think provide some useful guidance we're going to discuss today. So looking forward to an ad hoc discussion of all of those subjects with you today, Chucky.
Yeah, absolutely. So one of the things I think that makes the topics of virtual hearings an important topic right now is that I am actually in the midst of a virtual hearing where I'm the chair. I won't talk about that too much, particularly during the pendency of the hearing, but it's interesting having been a part of this being my first one and talking about virtual hearings and how courts have looked at virtual hearings. And I mean, bottom line, I think that they're here to stay. And probably the most overused phrase, which I'll use now, is that it's the new normal.
I wondered how long it'd take you to say that.
Right. So maybe we should start by just talking about what we've seen across the world. And this is a topic that people have been looking at across the world. And I think one of the things that kind of stuck with me and resonated with me in reading all the information that we read from the US to the UK to Australia to Africa is that courts on this issue of virtual hearings have been pretty consistent, right? And the arguments have been pretty consistent as well. So what arguments have you seen that kind of resonated with you and have been consistent around the world in the decisions that we've read?
So, I mean, starting with the underlying theme of a lot of the decisions I've seen, and that is the upholding of the central principles of arbitration, and that's party autonomy, and then the giving the discretion to the tribunal, having been appointed by the parties, to conduct the proceedings as it sees fit. Now, of course, there are various minimum standards which apply under arbitration legislation to tribunals. These generally provide for ensuring acting fairly and impartially, giving each side the opportunity to put its case and to comment on the case of the other, and to fairly be heard. And of course, the importance as well of adopting procedures which allow for proceedings to go forth in an expeditious, efficient and fair manner. And I think it's against that background, really, that decisions with regard to whether a hearing be held remotely or virtually tend to be judged. And the challenges that we have seen have tended to be where parties have alleged that for whatever reason, a decision to conduct a hearing on a remote or virtual basis somehow goes against some of those fundamental principles, particularly the principle and the right to have a fair hearing. Just starting off from the position in England and the governing legislation being the 1996 Arbitration Act, that provides sections 33 and 34 for those principles I just outlined with regard to conducting the process fairly, adopting appropriate procedures, and so on, and also giving the tribunal the discretion to decide procedural and evidential matters subject to those requirements. So we've seen a few cases which we'll come to from England. We've seen other parts of the world as well. But generally speaking, they seem to turn around those fundamental requirements that the tribunal should be entitled to put in place procedures, but it should do so to allow parties to conduct and participate in the process on a fair and equal basis.
Yeah, exactly. And so as far as the arguments that we've seen from the parties in these decisions and in these cases that have reached the courts, I think that the arguments that people make are those various things which are saying is, look, in this remote setting, I guess you don't have the benefit of being in the room with the parties. I know that there have been a couple of cases where there were going to be interpreters, and I think that people thought that the process would be too cumbersome and that type of thing. Like that's the due process is what you hear a lot, and people not being able to be heard. And those are the type of arguments that we're seeing from the parties. And I think what we've seen, again, going back to the consistency, is that the courts are saying, no, you're not entitled to a perfect hearing. What you're entitled to is a fair hearing where you have an opportunity to present your case. And not only that, right. And not only that. So any obstacles or any difficulties that you're feeling, party that's making the argument, that's bringing a motion, that's also being felt by the other party. So any difficulties are consistent with all the parties participating in the tribunal. And that's pretty much what we've seen. But why don't we go into some of the specific cases that we've seen in various jurisdictions? Does that make sense?
Absolutely.
Okay. So I'll start off with the one U.S. case that's kind of right on point on the arbitration issue we're talking about. And it's called, I might be pronouncing this wrong, Legaspi versus Financial Industry Regulatory Authority. So that's FINRA, that people in the U.S. will know it by its acronym. So FINRA is a self-regulatory authority. It's a private corporation, but a self-regulatory authority for people in brokerage firms in the U.S. and also for exchanges, and including the International Stock Exchange. So FINRA has members, and those members sign an agreement where they agree to arbitrate. Of course, an important part of the regulation by FINRA is arbitration and deciding disputes. So the members of FINRA sign an arbitration agreement which says that they'll have their disputes heard within the auspices of FINRA. So FINRA has a panel of arbitrators that hear these cases. So in this case, the claimant in the case filed in a motion for a temporary restraining order in the court in the Northern District of Illinois, which actually is right here in Chicago with me. And that's the federal court, and it's the trial court, so the court at the first level in this particular federal circuit. And they were looking for a temporary restraining order restraining FINRA from holding their arbitration in a virtual setting. And the court considered it. And I guess the thing that I really want to focus on in the court's decision is kind of what they said in response to this idea of the plaintiff or the claimant not having a fair hearing, because I think it touches on what we're saying. And I'll read the quote. It says, remote hearings are admittedly clunkier than in-person hearings, but in no way prevent the parties from presenting claims or defenses. So I think that pretty much sums up exactly what we're saying. And not only that, one disadvantage that the parties have when you're coming into court and you're making these arguments that the court shouldn't, or that the court shouldn't allow the arbitration bodies to conduct remote hearings, is that the courts have been conducting remote hearings. So, and the court talked about this in Lipinski, and they actually, and again, I might be pronouncing that name wrong, but in this case, the court had actually had a case where it used an interpreter, and it said, hey, yes, it's clunkier, but we've had no problems with these virtual hearings. So that's a little bit about that case.
That's really interesting to hear, Chucky. And so to give a bit of a counterpoint with the position in England, we haven't had a decision directly on a challenge to an arbitrator's decision with regard to remote hearings in the courts yet. But I think we can take a strong lead from the courts and the conduct with regard to their own hearings. As you said in the Legaspi case, there is a strong analogue, and courts will obviously, expect similar approaches and standards, well, where they're able to go ahead with their hearings. So the cases we've seen, since the COVID lockdown period was first with us here in England, are the National Bank of Kazakhstan and Bank of New York Mellon case, where it was held by the judge, despite an objection from one of the parties to a hearing going ahead on the virtual basis, that the default position was for the hearing to be conducted remotely. And he said that's despite the challenges which may arise. So there you have the court clearly acknowledging the challenges and difficulties. And then, as you pointed out, it may be more clunky, there may be more additional difficulties. But nevertheless, the courts will treat that as the default position. That was reflected in the re Blackfriars case a little while later. Similarly, in the case of Municipio di Mariana and BHP Group, again, there was an attempt by a party, the defendant in that instance, to vacate a remote hearing as a consequence of COVID-19. The court, having noted that its starting point was the need and indeed the overriding objective to deal with the case justly, also to have regard to proportionality with regard to the amounts involved, the importance of the case, and moving matters forward expeditiously and fairly, held that those considerations pointed in the direction of the hearing going ahead remotely, and the application was rejected. So that's all been interesting with regard to the stance the courts have taken with regard to cases which are before them. With regard to international arbitration, there was a degree of consideration, at least in connection with an international arbitration case, and that was in the case. And again, it might be my turn for my pronunciation to let me down, but in the case of Jiangsu Goixin Corporation and Precious Shipping Public Company Limited, there were two appeals came before the English High Court from two arbitration awards. And this was a shipping case, so concerning two shipping contracts. The court commented within that judgment that the oral submissions which had been made and had been done so by telephone link were, and this is a quote from the court, highly effective, and nothing of significance was lost by reason of the parties not being in the same place. So that's, again, a very firm steer from the courts to support remote hearings taking place, both in relation to matters before them, but also in relation to matters connected with arbitration.
So, and that's very interesting. So I guess where that leads us is, look, if you are a party that wants to go ahead with the virtual hearing, if you're an arbitrator that's deciding whether you want to order a virtual hearing when the parties can't agree on it, I think you're on a strong footing. But what about if you don't want a virtual hearing? Based on everything that we've been seeing, it is a difficult argument. But what type of arguments do you see potentially being successful?
Well, that's interesting, and I think you're right. I think parties might need to be creative. I think The key thing is really to show something that's distinct about that particular hearing, about the particular features or the particular facts, which would place it outside generality. Because we've seen general arguments about, perhaps concerns with regards to, witnesses not being completely viewed while they're giving evidence, speculative risks about them might be receiving additional information via text message outside of the view of the camera and so on. Arguments with regard to different time zones and so on have all failed to find favour. So I think rather than general speculation, I think what parties would need to do if they're contesting a remote hearing is really identify specific issues, specific risks, perhaps with regard to a witness given with regard to facts that they know, particular difficulties in relation to the nature of the case, which could set their case apart.
I agree. That's a good point. Something sui generis to your case, something unique to your case. And also, I think the point that you have to hit is that unique aspect of your case, for some reason, doesn't allow you to fairly present your case, present the evidence in your case. So I think if you're making that argument, that is kind of what you have to focus on. Again, uniqueness and the fairness to your ability to fairly present your case.
That's right, Chucky. And I've got quite an interesting example from Austria this time.
Okay.
And this is from the Austrian Supreme Court. A relatively recent judgment came out July of this year. And that is, as far as we understand, the first time that a court worldwide at Supreme Court level has addressed the issue of remote hearings in relation to international arbitration within the COVID-19 context. That case concerned an arbitration which was seated in Vienna, Austria, under the Vienna International Arbitration Centre supervision and rules. And there was an instance where the parties had considered holding a hearing remotely. One of the parties objected, but the tribunal proceeded to conduct the hearing remotely. The party which objected had its counsel and one of its witnesses in Los Angeles, California, which, given the time difference, meant that the hearing for them would start at 6 a.m., which was 3 in the afternoon Austrian time. So the objection which was raised with the court to the decision to go ahead by the tribunal was on a number of bases. One of which was the respondents claimed they effectively didn't have sufficient notice because although the hearing had been scheduled for a lengthy period of time, it was only a few days before the hearing that was finally determined that their objections would be set aside and it would go ahead remotely. There was also an objection because of the start of the hearing at 6 a.m. in Los Angeles time, which they said would amount to unequal treatment of the parties because for the other parties it would be 3 in the afternoon. And there was an objection about treating the parties fairly because there was this issue raised, which I mentioned, of measures to prevent witness tampering and the speculative proposition that perhaps the witness giving evidence to a camera from a remote location might be able to be subject to tampering or receipt of further information. But the Supreme Court rejected each of these challenges. And one interesting aspect it took into account in doing so was Article 6 of the European Convention on Human Rights. This guarantees a party's right to a fair hearing, access to justice, and so on. And the view was taken that in the context of something like the COVID-19 pandemic, where the option of a face-to-face hearing simply isn't practicable, the use of video conferencing and allowing the hearing to go ahead remotely allows for effective access to justice and allows the party that right to be heard, which is guaranteed under the European Convention of Human Rights, which has constitutional force in Austria. Similarly, the court was pretty swift to dismiss the arguments with regard to the time zones. What it pointed out was that if the parties had to all travel to a single location, they similarly would have been subject to waking up early to get on the flight, to jet lag, to various other inconveniences, and so on. So since the parties had chosen an Austrian supervised, an Austrian seated arbitration, the choice was likely to be at some point they'd either have to travel to Austria if there wasn't the pandemic, or conduct the hearing on an Austrian time zone, and the inconvenience and unfairness which might be said to arise from that was not considered to be sufficiently substantial to be a consideration here. And they, with regard to the question of witness tampering, it was pointed out that there are a number of practical steps parties can take with regard to witnesses. So there can be more than one camera on the witness, for instance, or a witness can give evidence so that the entirety of their body can be seen rather than just their head. And indeed, in some senses, video conferencing actually offers potentially additional safeguards. I mean, one aspect, and I've found this when conducting matters remotely, is you get a much better view of someone's face.
Yes, yeah, you do.
And the clarity and the facial tics and responses when particular things happen, which actually can be easier than sitting across the other side of a hearing room. So these are all just various considerations which feed in, but certainly in that case, which is the first time the Supreme Court has considered it, it was very much in favour of the hearing going ahead on a virtual basis.
Yeah, and then I'll also point out that the Supreme Court's decision again is consistent with everything we've seen thus far, and it's to me it's interesting how we see consistency from jurisdiction to jurisdiction. A couple of things I'll note. First of all, the argument about the witness tampering kind of sounds like the whole voter fraud argument that's going on in states right now. I'm not sure. Yeah, I'm not sure about that one. Secondly, I mean, of course, we have time zone issues too. I had to get up at the crack of dawn to do this podcast this morning, and I'm happy to do so.
I'm always impressed with how early you get up. So.
Yeah, right. So, what? So, switching gears a little bit. One thing we've seen is now that countries and arbitral institutions and a lot of people are coming up with protocols to try to address a lot of issues that we talked about in the case you just mentioned, which is witness tampering and that type of thing, setting up specific protocols. And I was happy to see Africa get into the mix and come out with its protocols, which are the African Arbitration Academy protocols on virtual hearings in Africa. And I thought that it was good and it was comprehensive. And I don't know if it really makes sense to point out some of the things that I saw in here. But I mean, a lot of the things are kind of common sense. I mean, wouldn't you say?
Yes, I think so. I mean, like you, I echo the fact that the African Arbitration Academy was very quick out of the blocks. It was in April or so this year, so early in the COVID context, they got this protocol out, and like you say, Chucky, elements of it are straightforward. And common sense. But I think what is important in it and what it does is it gets all parties thinking on the same page from the outset. So it states things that parties probably ought to have thought of or addressed in any event, but it ensures that each party and the tribunal is all on the same page.
Yeah, I agree. So is there anything else we can offer on this topic for our audience?
I think another aspect just on the protocol as issued by the Academy is it does try and consider some potential issues and concerns in the African context, because in some African jurisdictions there are, for instance, greater concerns about the absence of a reliable and consistent internet connection, for instance. So it very sensibly talks about things like backup provisions. It very sensibly talks about measures such as the parties all convening in good time ahead of it, testing all the technology, testing everyone's connection and so on. Also testing the backup so that it, give the best prospect of going ahead smoothly. But I think it's also important, for Africa, even COVID-19 aside, as you said, a lot of these changes are here to stay. And I think particularly where arbitrations and contracts take place between different African countries, the ability to conduct hearings and aspects of the process remotely is of great benefit, because there are often, and ironically often in Africa, more difficult travel connections between the African countries than there are between the countries themselves and to Europe, for instance. There are also potentially restrictions around visas and customs, particularly with parties from multiple countries, which might impede the transfer of documents and witnesses physically, at short notice. So the great thing about this protocol, and the great thing about people becoming more familiar with these processes, is I think that they offer a benefit not simply against the background of this pandemic, but overall to facilitate international arbitration much more generally.
Mm-hmm. Okay, I agree with all of that.
Yeah, well, so thanks, Chucky. So I think that was about everything I had on those subjects, but it was very interesting to hear those perspectives from the US as well, and to see that, broadly speaking, we seem to see courts taking similar approaches in multiple jurisdictions around the world.
And I think it's expected. Look, everybody's kind of got to get on the boat on this. I mean, if you aren't already, again, courts are doing it. Everybody's doing it. So it's going to be difficult to convince the court that, hey, you shouldn't do it in arbitration. So, and also I'll just say in arbitration, I mean, maybe not video conferences, maybe not the final hearings, but we have been doing a lot of it remotely anyway. So in arbitration is not something that's unusual. Just a few things about the experience that I was concerned about kind of going into it, that kind of really haven't played out as concerns, is, first of all, I mean, I think it's important to, as you just talked about, to test. We did it for the one I'm doing now. We did a test probably about a week before. We brought everybody on. So all of the various professionals that are part of it. You have the professionals who put up the exhibits and move through the exhibits and blow them up. So all of the what we call kind of trial tech people, all of the parties, the corporate representatives, all of them tested their connections. And since we've been on, I mean, it's pretty much gone off with no hitch. I mean, there have been a couple of people that dropped off during a hearing. Fortunately, the court reporter has never dropped off, but it might delay things for a couple of minutes, but we let them back in and we get started. So, but it's basically been a seamless process. And I think I was concerned about it kind of going good, and concerned about the problems and the challenges that could happen. And they really haven't been there. So it's been a pleasant experience so far.
Oh, that's great to hear. Fantastic. How long have you got left to run on it?
I don't know. Actually,
still time for something to go wrong.
Yeah. Actually, it's supposed to end on Saturday. We're doing it on Saturday to try to get it done this week, but we'll see. I'm hoping that we can get it done on Saturday.
Well, great. Good luck.
Yeah, thank you. And I created a bunch of, one thing that's kind of funny. I created a bunch of breakout rooms and all types of stuff that I thought we would need, and we haven't used them at all.
Well, it's good they're there.
Yeah. Okay.
Well, great, Chucky. Really good to check in. Really good to hear your views and observations. So thanks very
yours
much.
as well. Thank you.
Talk
to you later.
We hope you enjoyed this podcast. If you have any suggestions for topics or want to reach Kwadwo, Sarkodie or Charles Harris, you can find them at the Mayor Brown website, mayorbrown.com. Also, to learn more about other Mayor Brown audio programs, please visit mayorbrown.com/podcast. Thank you for listening.